Hello, students. This is Stephen Richardson from lawschool-essentials.com. And today I'm going to be talking about a question from the June 2013 California first year law student examination. It's the second question, it's a torts question. None of the information I talk about should be construed as legal advice. This is to help you out taking your exams in law school and Cal Bar exams. So we're going to be looking at this outlining and some very brief answers. So this is what first appears, what you'll first see, giving you instructions during the exam. And then I'm going to break down, we're going to read the call and the fact pattern, and then break this down in an outline format using the mnemonic memory guides from my website. You have to have this memorized. You have to go in. Everything has to be memorized so you can just click it right out of you, give you the maximum amount of time of matching the facts with the elements of the rule of law. Okay, so here's a fact pattern. First, read the call of the question. Is Bill likely to prevail on any intentional tort claim against Abe? Okay, torts. Intentional tort. Is Cindy likely to prevail on a negligence claim against Abe? Negligence. That's a long one. Is Debbie likely to prevail on a negligent action of emotional negligent infliction of emotional distress claim against Abe? So this is a racehorse right here. It's what you call a racehorse question. You have got to be on your game and moving fast. All right, so as you're reading this, Bill versus Abe, let's go up to the fact pattern. Abe wanted to cut down a tree that was growing on public property bordering his house because he did not want to rake its leaves. Well, that's reasonable. When Abe attempted to do so, Bill, who lived across the street, demanded that he stop. Abe refused and, holding his saw in front of him, took 2 steps towards Bill. Avoiding Abe, Bill climbed high into the tree, insisting he would not come down because he wanted to save the tree. Abe nevertheless sawed through the trunk of the tree, which fell onto the street with Bill in it, causing Bill serious injury. Cindy, a passerby, rushed to help Bill as she was assisting him. She was struck by a car and sustained serious injuries. Oh, poor Cindy. Debbie, a good neighbor, watched the entire a neighbor watched the entire incident from her front porch and suffered severe emotional distress as a result. Okay, as you're thinking of this, intentional torts, that narrows it down. There's 3 of them: assault, battery, and false imprisonment. So he approached Abe with the saw. You should be thinking about that. And then Bill fled, right? And then the battery, Abe cut the tree down, but you're saying, well, Abe didn't touch. There was no touching. Well, he cut the tree down that made the touch on the asphalt. So there's some causation there. And then false imprisonment, no intent to confine or restrain the defendant, insisting that he comes down. So you can mention false imprisonment and dismiss it. Okay, Cindy v. Abe, negligence. Oof. You got duty, breach of that duty, actual cause, proximate cause, damages, and any defenses to the negligence. You should have negligence memorized forwards and backwards. Okay, Debbie v. Abe, NIED. Is Debbie in the zone of danger? She might be on the fringes because she's a neighbor. Physically impacted? No. Was a bystander? Yes. However, the plaintiff and the victim are not closely related. Does not stipulate that. Most likely to fail. So let's move on to the torts checklist. You should take 5 minutes to do this checklist. It's pretty easy. The intentional torts, there's always a intent and volitional act. And then the battery is an attempt. The battery is is an attempted assault that succeeds, right? So they're very similar. And then defenses, I think that you could raise the defense of self-defense. That Abe thought that he might, when Bill came out to protest, he might have felt a little bit, someone rushing towards you, you might feel a little bit threatened, and then you take 2 steps and then the person flees, so it's reasonable for defensive self. And then the false imprisonment, volitional act, yes. Did he intend to confine or restrain him? I don't know. They were talking back and forth. Come down there. I'm not coming down. So I'm thinking this gets dismissed pretty fast. Okay, so this is what it'll look like. The answer take you 10 minutes. You make an introduction. The intentional torts requires a volitional act done with the requisite intent, which is the cause of the resulting harm suffered by the plaintiff. So the issue, tortious assault, under tort law, it's an intentional and volitional act done to cause reasonable apprehension of an imminent battery. Under tort law, battery is an intentional and volitional act to cause a touching of the person. So you're going to do your intro. You're going to say the issue, um, tortious assault or battery, and then you're going to cite the rule for both. Or you say assault, rule, fact pattern, battery, rule, fact pattern, and then make a conclusion. You got to weave those facts into the elements of the law. Okay. And you're going to need to make a nexus between Bill falling down and Abe cutting the tree. That's very important. Like I said, false imprisonment. You might briefly go over it and then dismiss it because he had no intent to hold him there. So it's 10 minutes to write your answer. Okay. And you could go back, you could pause and take a look at this. I'm going pretty quickly because I'm trying to do this in 10 seconds that you would have to write a checklist. So negligence, I'm giving you 8 minutes to do this checklist. Not 5, I'm giving you 8. And you should, boom, 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 this should come out fast. Did the defendant breach of duty? So there's plenty of duties there, and there was no special duty. So was a general rule of duty owed? The jurisdiction is Cordozo view or Andrews view? Zone of danger or duty to one is duty to all, like the Three Musketeers. Okay, was the duty breached? And I think the zone of danger is what applies here. Um, and Because Cindy was in that zone, the neighbor, she came and ran out. Um, did the defendant fail to act as a reasonable and prudent person? Well, um, you're gonna have to see if Abe. I don't think Abe was reasonable in cutting down the tree when the dude was up there. Um, and he knew that there's houses around. He knew there was houses around. Okay, actual and proximate. The but-for test for actual, proximate. Was there an intervening act? No. Then is the defendant direct cause of the injury? And was it foreseeable? Yes, it was foreseeable, and he was a direct cause. So foreseeable of Cindy seeing it or neighbors seeing it, because it's out in the public, not in his backyard. So yes. Are there any applicable? Oh, did he suffer damages? Of course, he suffered damages. So, are there any applicable defenses here? Did the plaintiff fail to act reasonably in his or own protection? Right. Bill could have came down and ran away. So there's a little bit of contributory negligence. Proximate, I wouldn't talk about the proximate clause. I wouldn't talk about comparative cause, but contributory, I would definitely contributory. Um, Assumption of the risk. Not Cindy didn't assume the risk, so I don't think that's a defense. All right, so here's you give you 20 minutes to write this. This is the longest one, and it's going to take some time because you got a lot of rule statements. You got to weave the facts in. So I'm going to let you read these rule statements, and again, you should have not necessarily word for word because these are textbook stuff, but very close. You should be able to crack these out pretty quick. It's going to take you the longest to write these rule statements, and then weave in the facts for each of the elements. So you got duty, breach of the duty, actual cause, proximate cause, and damages. Bill suffered serious damages. And defense, contributory negligence. The plaintiff put himself at risk by climbing high in the tree. The higher the fall, the harder the fall. With full awareness of the risk and a conscious acceptance of the risk. Okay, when you conclude, don't be conclusory. Indicate what courts will most likely hold. All right, and then a Debbie v. Abe. This is the easiest one. Negligent infliction of emotional distress. So this is pretty easy. Majority view zone of danger. She probably was Debbie. She's a neighbor watching the whole thing. Probably with the iPhone too, filming it. Minority view. It was the impact rule. Was the plaintiff physically impacted? No. Um, Bystander minority view. Yes, she was a bystander. Located near the scene. Oh, yes. And whether the shock resulted in a sensory and observance of the accident. Oh, yes. Was the plaintiff and victim were closely related? Neighbors, but I don't know. It doesn't say if they're related. And severe, yes, she had severe mental harm. So it's going to hinge on this relationship here. And maybe because she's a neighbor, maybe they're close. Who knows? Um, but but Cindy was a passerby, so Cindy doesn't live in the area. We don't know that. All right. So again, the issue NIED, you regurgitate the rule. Got to have this memorized. Head over to my website, Run Don't Walk, and take a look at these guides. They're very, very cheap. I know law students are on a budget. They're very, very cheap. Read it, write it, remember it. Little mnemonic things to help you um, pull those answers out the when you memorize these rules and the checklist. So in the analysis, the zone of danger, Debbie was a neighbor. She could be on the fringe of the zone of danger. Um, so don't be conclusory again. Indicate what the court is most likely to hold. And thank you for joining me. This has been a question on torts from the California First Year Law Students Exam, June 2003. Hope this helps you on your school exams and the Cal Bar. If you find this helpful, click subscribe, tell your friends, tell your family, tell your enemies, and I'll see you on the next one.